If you're an attorney managing high-value settlements, I'm talking 6 to 9 figure outcomes in complex civil litigation, then you know this. Resolving the case does not end the risk. In fact, in so many of our cases, the real risk begins at or just after the time of resolution. Here's something that I see all the time. You spend months to years into getting justice for your clients. You're navigating legal complexity, emotionally charged discovery, difficulties sometimes with the clients, financial negotiation, and finally, you get that outcome that your clients deserve and so desperately need. And then they end up walking away with a check and they don't have a plan. There's no guidance, no protection, no support. So what happens next? The clients lose SSI and asset-sensitive Medicaid programs because the funds were mismanaged. They burn through their money in 18 months because there was no structured settlement in place. They call your paralegal 3 times in a week in a panic, asking how to get their benefits reinstated. And even worse, they call your office to see if they can get another settlement for the same cause of action, which has already been released. Their resolution ultimately ends up becoming their vulnerability. And if things go sideways at that point, your law firm's name is still attached to that result. That's the part so many attorneys don't like to talk about or think about. And frankly, it's not your job to know every single nuance of post-settlement financial strategy, benefits law, or government compliance. But, as you know, it is your job to protect your client fully, and that is where I come in. I'm Joanna Wynes, a former trial attorney and settlement consultant. I partner with law firms across the United States to turn legal resolutions into long-term financial security without adding one more task to your team's plate. In this video, I will walk you through the 3 post-settlement mistakes that quietly cost clients everything they just fought for and how to prevent them. This is about protecting your client, reducing your law firm's exposure, and closing every case cleanly and with confidence. Let's get into it. Mistake number 1, I like to call lump sum logic, or really lump sum illogic. We got our clients the money, so they're good now, right? This is the most common and the most dangerous assumption I see after a high-value settlement. I've heard attorneys say, the client has received the check, and now our job is done. Let me show you how that thinking can unravel your entire case outcome. Imagine this. You settle a case for $1.5 million for your client after 2 years of litigation in a trucking accident case. The client has never seen that much money in their entire life. They don't meet with a structured settlement consultant, they don't talk to any financial advisors or anyone in advance of the settlement. They get a lump sum check, and within weeks, they're fielding advice from family members, insurance agents, friends, and even TikTok. No one explains to them the tax implications or the market risks of traditional investments. No one discusses government benefit limits. No one talks to them about having a plan to preserve that money long term. So what happens? What does your client do? They buy a house that they can't afford to maintain in cash. They invest in a friend's startup without ever looking at the books or having any idea as to whether it's a business they can even work in, or whether they're ever going to see any of that money back. They give gifts to relatives, long-lost friends come out of the woodwork, or they deposit everything into a standard bank account fully exposed. Fast forward 12 months, the money is gone, the client has no income stream, they're blaming the system, or even worse, they're blaming your firm. Like I said, this is what I call lump sum illogic. The false belief, the cash on its own creates security. But when you're dealing with trauma, high emotion, and financial inexperience, that logic collapses fast. And this is just even more so when you have a client who has a disability or special needs, if they've never managed large finances before, if they're under pressure from dependents or family members, or if they're emotionally vulnerable post-resolution, which again, so many people are. They're moving into the next chapter of their lives, and they need to have some guidance on how they do it. The truth is, most clients don't need access to $1 million today. They need a strategy that gives them what they actually want: peace of mind, long-term income, government benefit protection, and the ability to breathe again. Mistake number 2, government benefits are an afterthought. The client resolved their case, but they've lost their government benefits. Let's talk about one of the most costly blind spots in post-settlement planning: public benefit disqualification. It happens more often than attorneys realize, not because you missed something necessarily during the course of the case, but because nobody was watching what came next. So I had a case. I had an attorney call me one day, and she had clients come to her to look into a legal malpractice matter for a whole really calamity of errors in a case involving a young child with a brain injury. The original lawsuit was settled. It was not a ton of money, but it was a 6-figure settlement. This child was a young toddler. The original attorney ended up sending the settlement funds to a blocked checking account. In Maryland, it's called a Title 13 account. I know in other jurisdictions, it could be the registry of the court or a blocked checking account. But essentially, it was a checking account that was blocked, could not be used, and it was in the minor's name, so it disqualified this minor from benefits. So, subsequent attorney called me and asked if there was anything that could be done, because at this point, the clients have lost SSI, they lost Medicaid, they can't access the funds because they are blocked, and they are not going to generate any interest on their funds. So we ended up having to petition the court to release the funds from this blocked checking account and moving them into a special needs trust. Fortunately, we were able to do that, but it took the family time to get these government benefits reinstated. They lost money, they lost time, they lost medical supports during that time. And now this is just another aspect of malpractice that they're pursuing against the original attorney. So we just don't want that to happen to anyone. SSI and certain types of Medicaid are means-tested programs. Even a single deposit of over $2,000 into a personal account rather than a special needs trust can terminate eligibility. Once terminated, re-enrollment is complex, and it can often take months or even years, state-level bureaucracy. And again, in the meantime, your client is left without coverage and without any access to their child's funds. And they're going to, unfortunately, blame you. But this isn't about fault. It's simply about planning. And it's not your job to be a public benefits expert. However, it is part of your responsibility to ensure that the outcome you fought for doesn't create more harm than good. Mistake number 3. We close the case and we're done. Here's where this logic sort of falls apart. The case is over, but as we all know, our clients' problems are usually permanent. So a lot of times you're working really, really hard to get to, to prepare for trial, then you finally get to settlement. Then it's time to exhale. The case is settled, the release is signed, the check is processed. You notify the client, you send your final disbursement, and then you move on to the next case. But here's the problem. The clients don't move on that fast. In fact, for them, the most confusing part of the process is just the beginning, because now they're the ones staring at a stack of legal forms that they don't understand, a financial decision that they are completely unprepared for, government benefits that they'd like to preserve with zero guidance, and phone calls from benefits offices asking questions that they can't answer. And when that happens, who do they call? You. Or worse, your paralegal 5 times a week or even a day. Not because it's your job, but because you're the only professional they trust in this situation. And again, this is a mistake I see over and over in high-value litigation. People assume that settling the case and closing out the file is the same as completing the journey. But the reality is, without settlement support, the client gets overwhelmed. Your team becomes unpaid administrative support. Your firm's reputation becomes entangled in post-settlement chaos. And in the worst cases, compliance is violated, benefits are lost, funds are mismanaged. You did not go to law school for this, and your case management system was not designed to track post-settlement financial disbursements, Medicare set-aside compliance, and post-settlement claimant education. But this is where so many law firms get stuck. They're trapped in the invisible case after the case they thought was already over. Obtaining a settlement is only half the story. The other half is what happens after the check is cut, and that is where the real risk lives. I've seen million-dollar settlements turn into financial disasters. I've seen clients lose Medicaid, blow through life-changing sums, or end up emotionally and administratively paralyzed because nobody had a plan for the aftermath. And I've seen law firms, good firms, even great firms, end up stuck fielding phone calls, managing compliance chaos, and absorbing the emotional weight of post-settlement mess that they never signed up for. Not because they failed, but because they did not prepare the client for settlement or get a settlement partner involved. That's why I do what I do. As a former trial attorney and now full-time settlement consultant, I partner with attorneys across different realms of civil litigation to strategically structure settlements that increase client outcomes by on average of 200 to 400%. I help to legally protect public benefits like certain types of Medicaid and SSI through the use of trusts, ABLE accounts, spend downs, or a combination thereof. We handle all forms, documentation, and communications during the closing of the case and thereafter. And we offload approximately 10 hours of administrative work per case from your internal team. So you don't just end up closing the case. You close it cleanly, legally, and with total confidence that your client is protected and that your firm's risk is zero. If you're handling complex, high-value settlements and you're ready to stop carrying the post-settlement burden alone, let's talk. Click the link below to book a call with me. In 20 minutes, I'll show you exactly how we support attorneys like you, step by step. This isn't outsourced paperwork. This is strategic partnership built to protect everything that you just fought for. I'm Joanna Wynes. Thank you for watching.